We're on record today for a 90-day review. This is a case where we've had a termination trial proceeding that has ended up encompassing a number of additional reviews. In our last review, there were some updates from both parents, really, about some services. And so before I issue my final opinion and order on that, I'd like to have those proofs as well. I want to say that part of the delay has been putting this file together. We've had to look through for and request transcripts for several different hearings in order to make sure that all of the information is current and complete before I made my decision. So that's part of the reason for the delay in that, and I appreciate all of you being patient on that point. So I'm looking forward to the updates today after appearances.
Lee Heiss, lawyer, guardian ad litem.
Tasha Thomas, counsel for the department. Ms. Steele.
Good morning. My name is Heather Dale. I'm the foster care supervisor at Family and Community Services.
Michael Brooks, I represent the father, Caleb Anderson.
Michael.
Mr. Anderson.
Caleb Anderson, here.
Thank you.
Michael McFarland, representing Ms. Patterson. Please introduce yourself.
Sarah Patterson, mother.
Thank you. I have a proposed court report for today with a PHS 69 indicating a change in caseworker. So I appreciate those updates. Ms. Heiss, your report.
Thank you, Your Honor. I have visited with the children face to face. They are in a placement that is meeting all of their needs. Their needs are almost not heightened at this point. They're catching up to developmental milestones and they're experiencing normal traditions and holidays. And I intend to demonstrate some of the best interest factors when the caseworker takes the witness stand. Thank you.
Oh, I should note for the record, we did have a sidebar, and I basically repeated everything that I shared with the attorneys in the sidebar. Mr. McFarland, did you want to make any additional comments about what you shared?
Well, I just have some questions about visitation, but I'll bring that up in questioning of the worker yard.
Thank you. Anyone else have any comments about the sidebar before we get into testimony?
No.
No.
Ms. Heiss, any comments about our sidebar?
I think that you covered it sufficiently, Your Honor. Thank you.
All right, Ms. Thomas, you're our first witness.
Thank you. If Ms. Steele can be sworn in. Ms. Steele, you have been serving as the foster care worker in this matter, is that correct?
I have, yes.
And recently there was a change in workers, or can you just provide us a quick update on that?
There is a change in worker. However, I've still been managing the case firsthand as we proceed through these proceedings with the termination.
And as it relates to the court report that you provided, it includes the, there is no copy of the case service plans for the parents, but it includes the drug screen log for Miss Patterson. Is that correct?
Yes.
And are there any updates or modifications that need to be made to your report?
There are not.
And as it relates to the case service plans, have they been modified at all in the last review period?
They have not.
And this is a little bit of a different type of hearing, as we've already gone through the termination hearing, but to help the court in its decision, do you believe that there still continues to be barriers to reunification for the children with either parent today?
I do.
What are those barriers?
I guess the barriers would be a continued just addressing the substance abuse concerns that have been active throughout this case. The lack of bond between the parents and the children would be the main barriers.
And as it relates to services being offered to address those barriers, what has the agency done in this last review?
So Ms. Patterson has continued to be provided with drug screens through Runaway Development. We've continued to stay in contact with her service providers through McCullough Vargas. We've continued to stay in contact with both parents via phone, text, and mail. And then we've also provided transportation support to Ms. Patterson.
And do you believe that based on the barriers to reunification, the children should remain in care with their current placement?
I do.
how would you describe the parents' level of compliance with and benefit from their case service plans?
At this point, I would consider Ms. Patterson's to be partial compliance.
And Mr. Anderson?
He has availed himself to the services available to him in prison.
And have you continued to follow the incarcerated parent protocol?
I have.
And in your report, you highlight this, but can you just briefly articulate the risk of harm to the children if they were to be returned to either parent today?
Sure. The risk of harm if returned to Ms. Patterson would be potentially exposure to substance abuse, potentially exposure to domestic violence, and then potentially neglected overall exposure, or I guess risk of harm to Mr. Anderson would be, he is not able to care for them at this time as he is in prison.
Since our last hearing, has Ms. Patterson provided you with any proof of employment?
She has.
Okay. And is she still employed with Kesey and Hudson?
She is.
And as it relates to housing, is she still in? Can you give an update on her housing situation?
Her housing remains the same as previously reported. She resides with Mr. Anderson's stepfather.
And do you have any concerns about that housing?
Our concern with that housing as the home itself is appropriate, but there was concerns in regards to the history between Ms. Patterson and Mr. Anderson's stepfather.
Does Ms. Patterson have does she have any transportation?
She has reported that she's working on obtaining transportation, but I don't have any updates as if that's been confirmed or not.
In previous hearings, Ms. Patterson has stated that she was not going to smoke marijuana anymore. The drug screens that you provided continue to show positive use. Is there any concern about that?
I think the main concern with that is that she did testify that she wasn't going to be smoking marijuana anymore, but yet she is. If in the event we were looking at reunification, we would ask for safety plans to be developed regarding that.
There are no reports included from the McCullough-Vargas individuals who are working with her, but your report includes what information that you've obtained. Do you have any concern about her engagement with substance abuse treatment?
No, it has been reported that she has been actively engaged in the substance abuse therapy through McCullough-Vargas.
And so what parts of Ms. Patterson's case service plan is she not compliant with?
I guess the main areas that we would consider not compliant would be the area of substance abuse treatment. In regards to the other recommendations that were made in her psyche veil, it was recommended she participate in additional things other than just therapy. And then the concerns we have with her housing.
Are there any concerns about parenting skills or the services she engaged in to address that?
She did complete parenting skills at one point, or parenting education, I'm sorry, at one point throughout this case. However, we haven't had any observations of her parenting since parenting time would be suspended.
And at this time, do you believe that there has been such a change in progress that it would warrant reconsideration of the request to terminate the parents' parental rights?
I do not.
Do you believe that the children would know or recognize their parents today?
Maybe the oldest child, but I don't believe the youngest child would.
And these children have half siblings, correct?
Correct.
But they are not under the court's jurisdiction or receiving any foster care management?
Correct.
And policy only requires sibling visits to be addressed when the children are removed from the home and under foster care management.
That is correct.
Is there anything else that you'd like to update the court on today?
There is not.
Thank you. Your Honor, I have no further questions of this witness. Move to admit the court report and the drug screens that are attached.
No objections.
No objection.
I have no objection.
Thank you. They received cross-examination, Mr. McFarland.
You are aware from my client's prior testimony that she does have visitations with 3 of her other children who are 9, 11, and 13. Remember that?
I do.
Now, there's been no complaints filed with the state, Child Protective Services regarding her having negligent or abusive parenting skills with these kids, correct?
Not to my knowledge, no.
So that would be a demonstration, wouldn't you agree, that she is able to adequately parent without issues that brought her into this case to begin with, right?
I mean, there have been no CPS complaints that I'm aware of, so yes, I guess that is true.
And you would have you've never asked for an opportunity to observe her with these children, knowing that she's with these kids, right?
I have not, I'm not exactly sure what her visitation schedule is with them.
Well, have you asked?
She has reported that she gets them on weekends.
Okay. So you really don't have concern with her parenting skills if you're not looking into how she's parenting currently, right?
Those kids are not under our court's jurisdiction. I would not ask to observe her parenting those children.
Well, but you did give us an opinion about her parenting skills, but you've not observed her current parenting skills, correct?
I think I stated I haven't observed.
I'm going to
Fair
object to the line of questioning. Yeah, and I'm going to
Okay,
object to the
I'm
line as it is not relevant to the 2 children that are under this court's jurisdiction.
Well, Your Honor, the question that was posed by the attorney for the agency, or the answer that was given, it was my client's parenting skills in general. So I'm getting into parenting skills in general, and that was my last question that I was asking on that point anyway. So.
All right, did you get an answer to that question?
Oh, I did.
He seems to be agreeable to moving on to something else, Ms. Thomas, so I'm not gonna make a ruling on your objection.
Taking a look at my notes, it looks as though at least most of the testimony of this case concluded at a termination trial November of 2023 or thereabouts. Would you agree with that?
I believe so, yes.
Okay. Now, my clients, what was the drug of choice for my client, or addiction drug of choice?
I don't recall. I believe it was heroin.
Okay. Since over a year ago, she's not tested positive for heroin, correct?
I don't believe it was a year ago. I believe it was in May of 2023 that she had a relapse where she went to jail. And then I think it's been since June of 2023 that she's been clean.
Okay. So since June of 2023, she's not tested positive for heroin, correct?
Correct.
Okay. And the marijuana doesn't seem to be, nobody's reported an issue with her in minor regarding marijuana issues with anything, correct?
Correct. Like I said, the only concern we would have is we would ask for a safety plan to be implemented regarding that.
So I guess, I mean, there is some significance that she's not used heroin since, at least according to you, since June of 2023, right?
I would agree.
Okay. And at that time, she wasn't going to McCullough Vargas, correct?
Correct.
So how do you reach your conclusion that she still has an addiction issue to the extent that she shouldn't have visits with her children in this case? How'd you reach that? What's your thought process?
Just due to the lack of progress throughout the entire case, the services at McCullough Vargas only just started, not even, I think it's been about 4 months at this point. And then just the other recommendations that were made for her and her psychological were not followed.
You tell us what specific recommendations she's not followed from that psychological?
The only thing I can think of off the top of my head, I know there was numerous recommendations, I just don't have them in front of me, would be the participation in AA and NA meetings.
Do you know if McCullough Vargas is addressing those issues?
I know they do offer AA and NA, but I don't believe Ms. Patterson is participating in those.
But do you know if they are recommending that to her? Let me rephrase that.
They have not stated no.
Okay. So they're not recommending it. I mean, the cases can be fluid and can change, right? Is that yes?
Yes.
Okay.
Sorry.
Did I hear, well, when my client had her children of this case were visiting with their half siblings, correct?
Can you repeat the question?
Right, when my client was having visitation with her children in this case, these children were having visits with their half siblings, right?
I believe the oldest child attended some visitations. I can't recall if the younger ones did.
Okay. My understanding is that the placement of these half siblings and my client have requested at least contact with the bio children from this case, correct?
Correct.
Are you saying it's policy that the child not have contact with her siblings?
It's not necessarily policy. The policy states that kids in care are required to have sibling visits and where those kids are not in care.
Well, do you think it's in the best interest when the child was having visits with half siblings just to end those point blank, just cut them off like that? Do you think that's in the child's best interest?
No, I don't think it's in the child's best interest to not have sibling visitation. However, I believe the oldest child only attended 1 or 2 visitations.
But you don't know about the youngest, correct?
Correct. I would have to review the file.
Well, if it was determined that they were having regular visits, and the court does not terminate today, what are your plans for these kids to have visits?
I don't believe the kids were having regular visits with their.
I'm saying if your
If
investigation determines that they were, would that make a difference in them having visits or not?
If they were having visits, it's been a significant amount of time has passed since that has occurred. And so I would say, no, it's not in their best interest as they don't have a bond at this time.
But that wouldn't have been my client's fault, right?
No.
Okay. And the bond that my client does not have with these children, at least since November of 23, that's not my client's fault because there's a continuing order by the court and she not have visits, right?
Correct. Parenting time was suspended in May of 2023.
All right. So do you have any type of professional counselor today who would testify that if these kids had supervised visits that would be detrimental to the kids? Do you have a professional to testify today to that?
I do not.
Nothing further.
My client's earliest out date is August 2024, right?
That is correct.
Would that have any influence on your opinion that he should not be considered to get his children back?
It would not, no.
Thank you.
Ms. Heiss?
Yes, you testified that mother is testing negative except for THC. Isn't it true that she's testing positive for the medication-assisted treatment for heroin addiction?
That is correct.
So she is showing positive that she's taking her, these words are so hard.
Suboxone.
Suboxone, thank you. And at the last hearing, she indicated she was changing from the oral method of taking that substance to the shot. Has she changed?
She is still testing positive for Suboxone.
Okay, and then you testified for Mr. McFarland that she hasn't tested positive for opiates since she went to jail like last May or June, but she did test positive January 11th of 2024. Is that true?
Oh, that is correct. She did have a prescription for that.
And she had Oxycontin in her system at that time, correct?
Correct. And she, like I mentioned, she did provide a prescription for that.
And the prescription was because she hurt her thumb
Correct.
and she went to the ER
She did.
and she was treated with opiates.
She was.
So, has she tested since January 11th of 2024?
Yes,
And are those negative for opiates
they are.
except the Suboxone?
Correct. And
But-
the THC.
And you testified to Mr. McFarland that THC, nobody has told you THC is a problem. Didn't mom tell you that THC was a problem for her?
I think she had just stated that that was something she wasn't interested in using any longer.
Okay, so, you have not been able to gauge either the mother or the father's parenting ability with these children since May of 2023, because they haven't been visiting, correct?
Correct, because their parenting time was suspended.
So this is, thank you, Dave. Your Honor, may I ask a point of order? I believe that we are post-termination hearing, but pre-ruling on termination. So I would like to investigate best interest factors that wouldn't be relevant in a review. Should I do that now or recall the witness?
So I'm looking at the proceedings as though we have not concluded the termination petition. And that's because we've had the additional time that's elapsed, as well as, and I think that should be considered when I decide whether or not to terminate her parental rights and Mr. Patterson or Mr. Anderson's parental rights. So feel free to explore your best.
Thank you. Have you, these two children are both 2 years old, is that correct?
Yes,
And have you visited them in person in this last review period?
I have.
And at any point, did the children articulate to you a need for their biological parents?
No,
They didn't ask for mom or dad?
they call their foster parents mom and dad.
Okay. Did the foster parents indicate to you in any sense that the children are asking for the people that they visited prior to May?
No.
So these, both girls are 2, are they? Did one turn 3?
I think the oldest one turned 3 yesterday.
Okay, okay. So the youngest one has been in placement since birth?
Correct.
And so her visits have all been supervised with her parents, is that true?
Yes.
So any report from any of the professionals that are working with the children that they are experiencing trauma from being separated from their parents,
No.
their biological parents, have you observed the children in their placement?
I have.
And have you observed any bond between, let's talk about the oldest child, they're both K children, so initials aren't gonna help us much, but the older child with anyone in the placement home?
I have.
What have you observed?
They're very well bonded in their placement. They reach out to both foster parents for help if they're needing help getting a toy. It's a very normal environment for them. They have lots of toys available to them. They're constantly playing with the other siblings in the home. They're all definitely very well bonded.
So the some of the older kids have bedrooms in the basement, is that true?
That is.
And the little girls are have a fence so they can't go down there, correct?
I believe so, yes.
Okay, have you noticed if the 2 girls argue with each other, who do they look for guidance on a dispute?
Both foster parents or even the siblings.
When you observe that dynamic, would you say it's a normal, traditional hierarchy of authority in the home?
Oh, absolutely.
So do the girls overrun the foster parents?
No.
Do they mind the foster parents?
Like, do you mean go to them for like support?
Do they behave as directed by the foster parents?
Oh, absolutely.
And do the children seem to have any structure in the placement home?
They have quite a bit of structure. They do go to a daycare program.
Okay, in the daycare program, are you aware of any friendships or authority figures there that the children may be bonded with?
Yeah, they really enjoy playing with the other kids at daycare.
Okay, are the children able to tell you, well, the older child's verbal, is the younger child verbal? Are they able to tell you the names of kids they play with at daycare?
I don't believe I've ever asked, no.
Okay, or their teacher's name?
I don't believe I've asked specifically. I've just said like, how's daycare?
Okay, with respect to the little child, she is, have you observed her to look to the foster parents for guidance?
I have.
In what way?
Like when she's wanting a snack, she'll ask and she'll put her arms up to be picked up.
Okay, and does she have a living space at the foster home?
She does.
Does she share it with her sister?
She does.
And do you find that the children are in age appropriate bedding?
Yes, they are.
Are they both in cribs?
Yes,
Are the foster parents practicing safe sleep?
they are.
Do you believe that they are following the reasonable, prudent parent standard?
They are.
Can you give any examples of their parenting ability that you have observed?
The foster parents?
Yes.
Sure. They ensure all the girls' needs are met. They engage with early on services to make sure the kids are on track developmentally. The oldest child, she turned 3, so she's no longer qualifying for early on services. So the foster parent was making sure that if she needed any additional referrals, that those would get done. They're ensuring the girls have structure, age appropriate toys, and like you said, they're definitely following the prudent parent standard by making sure the kids have opportunities to participate in holidays, family traditions, birthdays, those types of things.
There are foster siblings in the placement, correct?
Yeah.
The children, you articulated that the children are bonded with those. They're boys, aren't they?
Yeah.
So do they attend the boys' school events or athletic events, any of those kinds of things?
They do.
I think the family roots for Ohio State, is that fair to say?
I think so.
For Halloween, I think the girls had Ohio State costumes,
I think they did, yes.
but we don't want to lose the case, right? Anyway, they're a family that really has a lot of, so would you say it's a child-centered family?
Absolutely.
How is the house set up to support a child-centered family? What is the geographic location of things?
So they have a ton of age appropriate activities outside, inside. If you walk in the house, there's like kids artwork everywhere. There's family portraits everywhere. In the girls' room, they have their names up on the wall. One side has one name, one side has the other name. It's definitely a child-focused family.
Okay, developmentally appropriate toys.
Yes.
And would you say that the house plan is open so that the children can be observed, whether they're in the family room, kitchen, or play area?
Yes, and then they have the gates up to where they don't want the girls to go.
Okay, so now comparing the placement home with the biological home, at this point, father is incarcerated, and does he have a home outside of incarceration?
No, I don't believe so.
So mother has a home, she lives with the children's step grandpa, is that true?
Yeah.
Okay, and that's the same person that in the beginning of the case, we heard about in the petition. Is that true?
That is.
Mom lives with the same person that we've seen some police reports more recently of disturbances at that home, is that correct?
Yes.
Does mom have a lease in that home?
I don't believe so, no.
At one point, you visited the home and found some safety concerns, is that true?
That is true.
There were some outside the house?
The concern was just that it was very overgrown, but the concerns that were identified at the home have since been rectified.
Okay. When was the last time you viewed the home?
I believe it was in October.
Okay, and did you observe beds for both children?
She had one crib up at that time, and she had since reported she has another one.
Have you seen the other bed?
Yes.
And developmentally appropriate toys?
A few, yes.
Is there evidence that other children spend the night in the home where the biological mom lives?
Yes.
And those children are older, true?
Yes.
So at this time, there are no safety concerns at the biological mother's home, correct?
Well, the concern would be who she's living with.
Have you observed any bond between the children and the mother or father since the visits have been suspended in May?
No.
Mother's employment at this time, is it long-term?
I believe it could be, yes.
How long has she had the employment?
I believe about 6 weeks.
And where is that? What type of work is it?
I believe it's a factory type setting. I think it's called KC Metals.
And it's full-time? So she's had that about 6 weeks.
I believe so.
Does she have a lease at the home she lives in?
No, I don't think so. She has reported wanting, other housing.
Have you reviewed her budget?
I have not.
Has she been employed before this job?
She has.
Constantly employed, or has it been sporadic?
Sporadic.
Changing jobs often, but normally employed somewhere. Is that
Yes.
accurate? Do you know if she pays rent at the home she lives in?
I do not know.
Do you believe there are any advantages of the child's foster home over the parent's home for either or both child?
I do.
What are those advantages?
The normalcy that's provided, the bond the children have with the people in the foster home, and then just the overall foster parent's ability to meet the kids' needs.
Can you compare the structure of one home and the child-focused nature of one home to the mother's biological home, the biological mother's home and its environment?
Are you asking me to compare like if the kids were in the biological home?
How about the way it stands now, even without the children, the police coming and that kind of thing?
Yeah, so in regards to the foster home, I mean, it's a very focused, child-focused environment, like we mentioned. All the kids' needs are being met. In regards to the mother's home, as mentioned, you know, there has been police involvement, and then, but other than that, obviously, we haven't observed the kids at that home.
Has mom been is mom up to date on the children's medical appointments?
She has provided medical passports, yes.
Do you know if she accesses the information?
She signs it, so yeah, she does review it.
Does she attend any of the medical appointments?
She does not.
Is it because her visits are suspended? And with respect to early on, has mother been active in communicating with the teachers?
I don't believe it's a teacher, but I don't believe she's ever engaged in the early on services, no.
I'm not sure if it's what that position's called, but does she receive reports from early on?
We have not provided her any, no.
Does she reach out to get her own information from early on?
She does not.
Does she contact the medical staff that's taking care of the children?
No.
She doesn't participate in decision making? The children have had some significant issues. Remind me generally, I think they've got tubes in their ears.
Yes.
And then they've had medical issues even over the since November. Can you review for me, was it colds that they were seeing or RSV? What was it that the children were?
I believe they both just had colds this winter. It was last winter that I believe it was Kylie had RSV.
Okay. Is mom or dad making any of those medical decisions for the children?
No.
I object, Your Honor. My client has no ability to make medical decisions. Apparently time suspended.
I disagree completely. She's a legal parent and has access to their charts and to their, she can't see the kids, but
That's
she
fine.
can.
I'll withdraw that. I'll question.
With respect to the two children, would you say that, I'm trying to get to their need for stability, a disruption in their housing at this point to change to any other foster home, to the biological parents, to a relative, would that be destabilizing to them?
Absolutely.
Would you talk to me about what is stable that would be disrupted?
I mean, I think their whole life is stable. You know, they have a routine. They're in daycare. They have the same routine every day. They wake up, they get ready, they go to daycare, they come home. It's the same household members. It's a very normal, structured day for them.
In the older child's history, well, I guess both of them, they've had different placements before this placement. Is that correct?
Yes.
Do you think it would benefit the children to be in one place permanently as opposed to changing placements?
Yes.
In what way?
It's always a benefit to children in their development to not experience more trauma, to be moved to different placements.
So they're looking towards the placement, mother and father figure as a mother and father?
They are,
And are those people performing traditional mother-father roles?
they are,
And the other children in the household refer to those two people as mother and father, correct?
they do.
In this placement, is it, has adoption been discussed with the placement?
It has,
Are they willing and able to adopt these children if the parental rights are terminated?
they are,
Are they a licensed foster home?
they are.
Is their license valid and active today? Do you see any barriers to them completing the adoption process?
No,
In this case, the children are placed in this foster care who is not a family relative, is that correct?
yes,
Is there any way to assess these two children and what their wishes are for staying here or going to a new place? Have you been able to talk to them at all?
no, I mean, they're only 2 years old. Well, the one just turned 3, but
Okay. They're catching up a little bit verbally, would you agree?
yes,
So they're not especially articulate, correct?
they are not, no.
You articulated that the youngest child might not recognize her mother in your estimation.
Correct.
Did you say whether the oldest child would recognize her mother?
I had just said I wasn't sure how.
And then the same for the father, same response?
I'm gonna say no to the father. It has been a significant amount of time since they have seen him.
And has he provided for any of the needs for the children while he's been incarcerated? They're both still in diapers, correct?
Yes,
Has his mother provided any outfits or diapers or needs for the children?
she did give a couple items at the last court hearing for them, and she has asked about their sizes.
Okay, did she provide any Christmas cards or gifts?
No, or yes, she actually did. I'm sorry.
Okay,
She did when we did that visit with the grandparents.
okay, so judge allowed a visit with a ill family member?
Correct, yes.
When you observe these two children, do you observe any bumps or bruises on them that cannot be explained by the caregivers?
No,
Would you say that they are socializing normally for their developmental stage?
they are.
And would you say that they're eating properly for their developmental stage?
Yes.
Now, the little one she didn't exactly crawl, she kind of scooted and army crawled. Do you recall that?
I do.
Is she walking now?
She is.
And would you say that their walking is on target at this point?
It is.
In the foster home, has the couple been married? Is the couple married?
They are.
And have they been married for a long period of time?
I believe so, yeah.
There are other children in this home that we talked about 3 boys, correct?
Yes,
Do you perceive that their needs are being met?
yes,
And you're aware that one of those children is undergoing medical procedures, correct?
I am.
And despite he's been hospitalized for maybe a month-ish
Yeah,
with
A week.
very high needs.
yeah,
Just even though that has been happening for the family, there's been an adult with the children all the time for supervision, is that correct?
that is correct.
There's a grandmother that comes in and out of the house to help.
Yes.
Is that the foster father or the foster mother's mother?
I believe it's the mother's mother.
Okay, so this grandmother is in and out of the house daily or often.
Correct.
Do you perceive then that part of the stability in the home is that they eat meals at a dining table together?
They do.
Have you observed any? Do you know if the older child is potty training?
They're working on it, yes.
What do you know about that?
That she hasn't really had much interest in it yet, but that they are trying to get her to go. It sounds like they were also working on it at her daycare as well.
And do you know if they have proper attire prepared for when she switches over?
They do.
And then have you noticed any area for brushing teeth, for example?
They're up to date on their dental exams, and there's been no concerns in regards to their dental care.
Okay. Thank you, Your Honor. That concludes my questions.
Okay, redirect, Ms. Thomas,
No, Your Honor.
recross.
Thank you. Guardian ad litem has asked you if mother's ever made a medical decision. I want to go since her testimony at trial. Well, let's say since, I guess, when is the last time mom has had the ability to make medical decisions in your point of view?
I would have to recall the file, I'm not sure.
So do you send her notices of when the kids are going to the doctors?
I do not.
Do you send her any notices about the results of the children's doctor's evaluations?
I believe I mentioned to her that the youngest child did get tubes in her ears, and then as mentioned, she does receive the medical passport, which lists out all the appointments and the outcomes of those appointments.
Okay. So why isn't she able to make decisions for these kids? Medical decisions?
In regards to just their like well child appointments or surgeries or?
Anything? Because you've answered, the guardian ad litem asked you, is mother able to make medical decisions? Has she made medical decisions? And you said, no. I'm asking you, does she have the ability, in your point of view, to actually make decisions?
I mean, yeah, she definitely would have that opportunity. If she reached out to me and had questions or anything like that, we would definitely provide that information to her.
Well, couldn't she virtually attend these doctor's appointments so she could have some input?
She could.
Has that ever been offered to her?
It has not.
Okay. What family member did this child, I think it was a maternal grandmother that the children had a visit with, correct?
I believe so, yes.
Okay. So how many visits since that have you allowed this maternal grandmother to have visits with these kids?
They just had the one visit.
Why haven't you tried to keep that that grand maternal bond? Why haven't you continued these visits?
It was just court ordered for that one visit, so that was the only visit we did.
I realize that, but why haven't you tried to keep the visit with immediate family, which is the grandmother?
Agencies just don't usually reach out to extended family members for visitation.
I haven't seen your report that the child does not have a bond with grandmother. That would be, I haven't seen that, correct?
Correct.
Okay. And did I hear you correctly that you testified mother stated to you that she wishes not to remain at this current location?
She did.
Okay. Did she tell you she has $3,000 saved up to move?
She did not.
Okay. Okay. You realize this court could render a decision of termination of her rights, or could also render a decision not to terminate her rights, correct?
Correct.
So what safety plan do you have in mind if the court decides not to terminate her parental rights?
In regards to the marijuana use?
No, in regards to my client reunification. If this court does not terminate my client's rights today, you have a safety plan devised for her to proceed with reunification.
We would just continue with the case service plan. We would ask if reunification was going to be continued, we would ask for therapeutic visitation.
Okay. And so you've not really prepared for my client having reunification with their children. Would that be accurate?
Like in terms of making like a referral for therapeutic visitation?
Correct.
We have not made that referral, no, because her parenting time is suspended. So that wouldn't have been something we were able to do.
So if this court were in the interim to allow my client to have supervised visitation, what would we need to do to get that started?
We would, if it was therapeutic, we would make the referral for that to get that started as soon as possible. If it wasn't therapeutic, we would schedule her visitation at the Lenawee DHHS.
The court ordered that this child have contact immediately with her other siblings, with these children of this case have contact with the other siblings, the half siblings. What steps would this agency
The
take?
same situation, we could also explore community settings for this, like libraries.
So if my client's intentions are really to move and placement, you would never suggest to the court immediate return of the children to my client without therapeutic visitation, right?
We would not.
Okay, nothing.
Mr. Brooks?
No questions.
Ms. Deal, did you actually call LDC to find out what the next 3 drug test results demonstrated?
I have received, I would have to look at the date specifically, but any additional testing other than what's provided was positive for Suboxone and THC.
Only. Okay. Were you able to go back out to the home during this last report period?
We did not know.
Okay. Ms. Heiss, did you have any more questions?
Just one, is it the agency's position that it's in the best interest of the children to terminate their biological parental rights?
Yes.
Nothing further.
Any other questions based on my questions?
No.
One.
No.
You're not holding it against my client that she's taking Suboxone, correct?
No.
Nothing further.
I'm sorry, Ms. Thomas, did you say yes or no for questions?
I have none. Thank you.
Thank you for your testimony. You may return to your seat. Any other witnesses, Ms. Thomas?
No, Your Honor.
Okay, Mr. Garland,
I have 3 witnesses, Your Honor. I wonder if this might not be a time for a break.
for purposes of today's review,
Yes, review and to also go over the best interest factors.
if I could have just the names of your witnesses and a brief idea, an offer of proof on which witness will be.
My client to testify as far as her current progress, Your Honor.
Okay.
I also have the stepmother, where her other biological children are placed, to testify as far as her current parenting skills, Your Honor. I also have a biological child in the court today to testify about her bond with these 2 children in this case and her desire to continue to have sibling visits.
Mr. Brooks, will you have witness testimony today?
I will not.
Ms. Heiss?
Potentially, I have foster placement, but I don't intend to call them.
Okay. Any objections to Mr. McFarland's witnesses?
How old is the child?
21, she's sitting behind you.
Oh,
Or 20.
all right. No objection.
Your Honor, as it relates to mother testifying, I don't think I have grounds for an objection other than I don't have any proofs that have been provided to me from Mr. McFarland. As relates to her children's stepmother and parenting skills, as I've already objected earlier, don't believe parenting skills to children who are significantly older, not similarly situated to these children, and are not under the court's jurisdiction is relevant at this time. And then as it relates the half siblings bond with the children, desire for sibling visits, again, I don't know the relevancy here. These children have been removed from their parents' care and custody, I believe, since birth, just a few months old. And so the bond or lack thereof with extended family members, I think, has been discussed sufficiently. The last, has this case been open for 2 years or so? So it's been over 2 years. So I have no, I don't believe it is relevant at this time.
I could respond, Your Honor.
You may.
Your Honor, the question of the agency witness was my client's parenting skills, not specifically with these children, but it was her parenting skills. We're also asking prayer for relief today for my client to have parenting time. For the court to consider that, I think that's always an option for the court to consider. I think the court would like to know what my client's current parenting skills are to see if she would have the ability to parent these children. One of the best interest factors are the bond with siblings. And my other client's testimony would, and both of my other witnesses would describe the bond and the bond that's not been continued, Your Honor. So I think that is directly addressed in the best interest factors.
Any position, Mr. Brooks?
No, I'll support Mr. McFarland.
Ms. Heiss?
Yes, I think that the other bio children are not similarly situated. They're verbal. They have had a history with the parents, and their bond would be completely different. It would be apples and oranges and a waste of the court's time to understand the differences. And I don't know that there would be differences, but if we were to really look into not just what they present today, but what their other data is, I think we would be here a long time. But also the biological sibling, I don't know what the relevance is of any bond information. If there is a bond, it's from one visit since before May. And also starting visits, the attorney can present the family wants visits. So I don't think those two, I'm eager to hear from mother, and I have only the foster placement if needed as a witness.
Any other comments, Mr. McFarland? Before I make my ruling?
Oh, Your Honor, there's also some testimony given by the worker about concerns about my client's prior addiction history and her dealing with drugs. And I think testimony of my witness who directly visits the house, the stepmother of the other children of my client, that she'd be able to testify directly as far as the condition of my client's house, the condition of my client, her appropriateness around children would also indicate her biological children. We could extend that to the other children who are in foster care placement. So I think it's relevant testimony, Your Honor.
Thank you. As far as the bond with regard to the older sibling, I don't think that that's relevant for the reasons that were articulated by Ms. Thomas as well as by Ms. Heiss, which is namely that particular bond would not be similarly situated. Plus, the record has to speak for itself as it relates to the bond between this parent and child, and all of those hearings during the period of time where she had visitation speak for themselves, and any contradictory evidence should have been heard during that time. If she has any observations about or if anyone has any observations, including the stepmother or the older child, about observations of Ms. Patterson with her children, those should have been raised during the review periods wherein it was witnessed or addressed. So for those reasons, I'm not going to allow the presentation of proofs on that point, which I think eliminates the reason for the sibling that was requested for purposes of testimony. As it relates to the parenting, also your client, the record speaks for itself as far as her parenting goes during visits, and all of those things are also in the record. So how she behaves around perhaps older children that are not similarly situated really has no relevance to how she is approaching this particular case. And if it does, then it should have been brought up during the period of time. For example, when we had to relegate your client's parenting time to once a week because of issues that were happening during parenting time. And then again, when it had to be relegated to supervised only, that would have been the appropriate time to bring testimony as it relates to her parenting time. The record speaks for itself on those points. So for those reasons, I am going to deny the testimony of the stepmother and the sibling, but I will of course allow Ms. Patterson to take the stand on those points. As it relates to the home where Ms. Patterson is living, I would need you to lay more foundation as far if the stepmother is able to testify to that or not. She's on that point. Do you have any further?
Yes, Your Honor. I do have a question for clarification also, but yes, my understanding is she is present at the house. She's been there. She can testify to the conditions, the current conditions.
That's just, okay, so when was she there? What is she gonna be able to tell us that she saw? How often is she there?
I don't know that particularly, Your Honor. Also, I thought I heard the court testify that you were going to treat this as a continuation of the termination trial. And I think these witnesses I would have been able to bring at the termination trial, just for the record.
This is a review which is consolidated with the termination trial, so in that context, you're correct, but you're also limited to things that have happened in the last report period because of the continuing record that is our proceeding. So for those reasons, the court's rulings remain the same. I also do not find that we have enough, based on the offer of proof at this time, to allow the stepmother to testify as it relates to the current living conditions of Ms. Patterson.
I guess would the court then reconsider that on the testimony of my client if she were to testify, the frequency and the observations this client would have made? I'll make that most of the time.
Thank you. Very good. All right. I have no more time available to you today for purposes of testimony, but I have tomorrow commencing, I think, at 10:30, assuming that the 10 o'clock would only take a half an hour, Ms. Thomas. I look for your thoughts on that.
Your Honor, I think the pretrial itself will be pretty short. I think we're really just waiting on this court's direction on that case. So if that's agreeable to me, I would have to appear via Zoom and have a hard stop at 11:30, as I have an appointment that I have to attend.
Okay, Mr. McFarland, would you be available commencing at 10:30 tomorrow?
Am I on the 10 o'clock case?
I don't know.
Oh, well,
No.
yeah, I'll be here, yes.
Ms. Heiss?
I am available. The agency caseworker is asking if she can participate by Zoom.
No objection.
Yes, that's fine. Mr. Brooks, do you want a ruling on your client's case today? Do you want to come back tomorrow morning at 10:30?
I'll come back tomorrow morning.
All right. Okay, so Mr. Anderson, we'll do our best to make sure that you're able to rejoin us tomorrow morning at 10:30 as well.
Okay.
Okay, thank you, everyone. We'll see you tomorrow at 10:30 on the record to conclude the review and permanency planning hearing and testimony on a petition for termination of parental rights for both parents. May I have the names of our participants, please?
Lee Heiss, lawyer guardian ad litem.
Ms. Stasia Thomas, counsel for the department. Ms. Deal.
Good morning, I'm Heather Deal from Family and Community Services.
Michael McFarland, representing mother.
Sarah Patterson, mother.
Michael Brooks, I represent the father, Caleb Anderson, who may be or may not be on YouTube. I don't know.
He is here,
Caleb
Mr.
Anderson
Anderson.
here.
Thank you.
Caleb Anderson's here.
Thank you. All right, Mr. McFarland, you had a preliminary matter.
I do. My client has not been receiving the court orders. When we're off YouTube, she has provided on several occasions her address, and she had to go across the hall today and have the orders copied for her and provided to her just today. So we can, again, when we're off the record, give you her address again.
Very good. Yes, I don't have in the file that it has been updated since February of 2022. Although, let me take that back. It looks like Manitoba Beach area as of January 26, 2024. So it is in the file, as well as a Gmail address with a 29 in the middle. All right, so hopefully at least the emails we're going through. That's typically how we,
Yes. they will.
yes. So she should have had the emails, the court report and attachments and those orders through email. Okay, all right, you had testimony from additional witnesses?
We're actually going to limit it to my client. Have an exhibit. I will introduce. I've shared that with everybody. Nobody has objected last time, so if I can have one marked for the court to do, then I would like to call my client.
You may approach. Ms. Patterson, you head to the witness stand.
Sarah, couple things. Are you employed?
Yes,
Okay, where are you employed?
Kesey's Metal Technologies in Hudson.
Okay, I know last time when we were here, I believe you had some injury to your thumb. Is that
Yes, I'm
correct?
still off work, but I'm on workman's comp right now. So,
Which thumb was it?
my right thumb.
Okay, can you please show the court what injury you received?
I got my thumb stuck in a machine at work.
If you can just show that to the court.
Actually looks a lot better than what it did.
Your Honor, we have a thumb to present to you.
That
Thank
looks
you.
better.
Thank you.
Are you going to submit the thumb as an exhibit?
I'm not keeping it.
Why? Come on, McFarland.
I just want the court to know that it's a true injury. So what happened to you at work?
The machine was acting up and it's a hydraulic press. The part got stuck when I went to hit it with the mallet like you normally do it. Just the part flipped and it hit my thumb, pushed it back, and it got like pulled my thumb back within and it got stuck in the machine. And it was stuck there for a good 5 minutes.
Painful then.
Very painful, yes.
So despite that, you're receiving some unemployment, correct? Workers'
Workman's
compensation.
comp, yes, until yep.
And you anticipate to go back to work when?
Right now we just go week by week. I'll probably go back. He said not this. I'll have another week off, so I'll go back in 2 weeks.
Okay. And will that be full-time?
Yeah,
And I've asked you before, I'll ask you again, are benefits available for you and the children in this case?
there's medical, dental, vision. There's life insurance, short-term, long-term, all of that's available, yes.
Do you have a checking or savings account?
Both
How much do you have saved up right now?
$2,321.
Okay. If this court allows you to have visitation, continue this case for reunification, do you intend to stay where you're living, or with those savings, would you be looking for someplace better?
I plan on looking for my own place for me and my children.
And you have the funds to do that?
Yes,
What's your transportation situation right now?
I just recently bought a car.
And do you have a driver's license?
Yes, I do. I have a driver's license. My car is insured, and I have an appointment at 12:20 today to get the plates on it.
Great. Okay. So transportation is no longer an issue, correct?
No, absolutely not.
And are you still going to any type of drug rehab program or anything like that?
Yeah, I participate in my McCullough Vargas program with Peggy. We do all my stuff through them.
And they have Peggy Moeller, is she who you're seeing?
Yes, that's my therapist.
Your Honor, I have presented a letter to all the attorneys last time in court, and they didn't object then, so I'd like to have that marked as exhibit and entered as our exhibit.
My understanding is that's already been agreed to. Is that right, counselors?
It is.
It was my understanding she was gonna be here today to testify. Is that not the case?
That's not the case because we have the letter. We're just going to use the letter.
I have no objection.
Ms. Thomas?
I have no objection.
Thank you. It is received as Respondents Exhibit 1.
Okay. And I know last time there was some talk from the guardian ad litem, I believe, about you not going to AA, but this letter addresses your program being more intensive than AA. Is that correct?
Yes, that is correct.
What are you actually learning from this program? I mean, I know she says you're going. Tell the court so they know that you are learning. What are you learning from this program?
I've learned a lot, actually. I've learned that I don't really need a man. Before, I think that was a lot of my problem. I think was codependent on things, and I learned I can actually do things on my own and actually get them done a lot better being, just Sarah, clean, sober Sarah. I've learned that I honestly did have a drug problem. I was in denial about it. There was a lot of things I've done wrong my kids have suffered, all 6 of my children. I've learned how to, instead of acting out, I'm sure you've all seen Sarah act out a fool and that terrible Sarah, but I've learned how to channel that and put that energy, I don't act like that now. I act cool, calm, professional. I think about things. I've learned a lot. So
What's your sobriety date?
my sobriety date, so me and my therapist talked about this. I was incarcerated last year. I believe it was May, I can't remember the exact date, but of 2023. And then I got out for 2 weeks, went back in 2 weeks later, and then I was incarcerated till June 19th. So technically my sobriety date is in between May and June of 2023 last year, not October 2023.
Thank you.
So it's almost coming up on a year. So I would like to be credited for my whole year of sobriety that I've got, because I got a car yesterday on my own. Sarah did this. And I just sat there and I looked at my father-in-law. I said, I'm so proud of myself. I've come a long way. And regardless if you guys think or whatever, because of my mistakes I made, that doesn't make me a bad mom. That doesn't, you know what I mean?
Let me ask you, has the worker in the last 90 days met with you in the event that your parental rights are not terminated as far as what you need to do to progress to get your kids back? Have they had that meeting with you?
Not one single time, no, sir.
Have they-
There is no intention of me getting my kids back from that side of this. There has never been no intention of me reuniting with my children. It's always been, we're going to terminate your rights, take your children, and there's no intention of me being reunited with my children. There is not.
How many children do you have right now, adult and minors?
4. I have a 20-year-old, 13-year-old, an 11-year-old, and a 9-year-old, all girls. And then a 3-year-old and a 2-year-old.
And do you have any visitation rights with the minor children?
Absolutely, whenever I would like.
Don't want their names, but how old are these? The minor children?
They're 9, 11, and 13.
How frequently do you have visitation with them?
I can see them. Our work schedules, we accommodate around it, but I can plan with my ex-husband and his wife whenever I want. I could see them today if I wanted. You know what I mean? As long as it accommodated their schedule.
And your ex-husband's wife, she's here in the courtroom, correct?
Absolutely.
Prepared to testify, correct?
Yes.
So how frequently let's say in the last 90 days, how frequently do you visit with them?
I see them every week. I see them weekly. At least once, twice a week. And then I'm on the phone. They have phones, so we're on the phones all day. I see them, we FaceTime. So
And your visits, are they supervised or unsupervised?
they're supervised right now. We just keep it that way. There's no.
And are you requesting today that you have supervised visits with the children in this case?
Absolutely. I've been requesting for the last year since I got out of jail and have been clean to have my visits back with my children. And every time it's been adjourned or dismissed or whatever.
How is this does this affect you at all, your mental state, since we started the trial, I think it was November, or at least November of last year, we were in this trial. Is this affecting you at all?
Yeah, absolutely.
How does that affect you, not visiting your kids for this long?
It affects me deeply to know that I've got 2 kids out there that don't even know anything about their mother. They know nothing about their sisters. Like, I got pictures of them and I looked at these girls and I compared them with my other kids, and like, I was with my 4 older kids, I was active from birth till my oldest is 20. I never missed a beat. I didn't miss all the first stuff. I've missed 2 birthdays now. My 3-year-old just turned 3 this month. And I didn't even get to celebrate. My 2-year-old turned 2 in October. I didn't get to celebrate. That's things we don't get back.
Now, you told me that you have presents that you would like to give to the worker to provide to.
I actually took it upon myself last time and I spoke to the foster father and I arranged with him after court last time. We exchanged out in the parking lot and I was able to give them to him.
Okay. And you have no ill will towards the foster parents, right?
Absolutely not. Absolutely not. I appreciate the foster parents more than anybody could ever know. I didn't know they were going through everything they're going through, and honestly, I've been praying for the situation, and I'm very grateful that a family like them took in my kids, because it could have been much worse. And they are a very, very good family, and that's from the bottom of my heart. Like, absolutely, there's no ill will, never will be.
Now, the individual you're living with is the grandparents of the kids, which is Mr. Patterson's dad, right?
Yes.
Do you intend, when you get a place of your own, to take him with you?
No, Rod owns his house. Okay. Rod's staying at Rod's.
So if this court were to allow you to have visitation, how soon would you be then looking for a place of your own?
I've already been actively looking for a place of my own. I'm still seeking and looking, you know what I mean? I've got the car, got it all legal, and it's just a matter of finding a place that accommodates my location, my kids, and my work area.
So your planning, your search right now includes residency for the children. Is that what I'm hearing?
Yes, absolutely.
Now, do you know when the last time your kids who are in foster care have had any contact with their siblings who live with your ex-husband?
That would have been since back when my sister originally had them. It's been a very long time. It's been 2 years.
Your other kids miss having contact with their
Absolutely.
younger siblings?
Absolutely.
What about your adult daughter? Does she want to have contact with?
My kids ask me questions like, Mom, how come we can be around you and you can do things with us, but we can't see K3 and K2? And it's hard to, explain that to them. And I do talk with my kids. They do understand that I had a problem, that Mom had a drug addiction. They know that I went to jail. My kids tell me every day how proud of me they are and how lucky I am that I have beautiful kids, a good job. Like, my kids are very much missing their sisters.
Now, when this was an active case and you were having visits with your kids, you did regress and you went back on drugs, correct?
Yes, I did. But honestly,
Well, just let me finish my
sorry.
question. Okay. What were your triggers at that time? What caused you to do that? And then the second part was, do those triggers still exist right now, and how do you deal with those? So let's first of all go, what was it? What were
my
your triggers?
triggers were the fact that I had like 3 or 4 caseworkers on my foster case. I had reached out several times, expressed my opinion. I was trying to be clean, trying to take it serious, but nobody took me seriously. Everybody dismissed Sarah. And that's what I figured out with Peggy. Peggy showed me that Sarah don't have to be dismissed. You are a lawyer, you're a judge, you're this, you're that, but you all are accountable and held up to the same standard that I am held up to in this case. And ever since I've learned this about myself, there are ways you can go about and make yourself heard and be assertive and this and that without acting a fool. And So I learned, instead of going to my worker and all this stuff not getting done, I'm gonna make action for myself and I'm gonna make things happen. So, and that's what I've been doing ever since. I've been making the phone calls. I've been putting in the effort. Somebody said last time we came, has she called the doctors? Is she part of the doctors? Called the doctors last week and they won't give me a lick of information because I'm not on anything. How am I supposed to be part of, you know what I mean? Like, I'm trying, and it's things like that. But it's before I would have got frustrated and been like, nobody wants me to be a parent to my kids. It's hard to explain. It was really hard. And instead of turning back to drugs, I decided to be productive, stay clean, and I'm going to fight for my kids. I don't care if we can be here for 6 years. I've got time. I'll do it.
So since our last review, I'm not talking last time we were in court, but the time before that, have you received any information about how the kids are doing other than
Other than the court.
other than the court report?
No.
Have you been invited to participate by Zoom, just follow a parent-teacher conference? Well, actually, there's no
Well,
parent-teacher
there's- yeah,
conferences
none
for
of
this. How about a doctor's appointment? At
No.
least be in a Zoom or a waiting room to find out what's going on,
No.
have input.
I have not been involved in nothing, absolutely nothing to do with my children, nothing. And it's been like that for over a year now. I was able to participate in one doctor's appointment that I was able to go with the foster mother. And I kind of actually, like, at that time, I think back and I look now, I wished I would have not been such a jerk. You know what I mean? Because I was mean and like just still mad. And instead of like seeing it now that like these people are kind of taking my kids, you know, like they did something I couldn't do at that time. And I'm so thankful and blessed for that. Like, but it was helpful, I thought, for her to have me there because like at that time the baby was in a car seat, you know, and you got a toddler, and I just wished I would have been a little bit more professional acting and I wasn't such a jerk, you know, about everything back then. But I've learned and I've changed and I can only go forward. So
Now, you're counseling with McCullough Vargas.
Mhm.
If this case were to close tomorrow,
I would still do counseling.
I was going to ask you that. And is there anybody you turn to as a support other than McCullough Vargas?
My family, my friends. I mean, I have a lot.
Well, tell us who these support people are. 'Cause
My
we
mom,
can
my
recognize-
dad, I have 8 brothers and sisters, 2 brothers, and the rest are sisters. My nieces and nephews are big supports. My kids, my kid's stepmom is a big support. My ex-husband's a big support. My ex-husband's mother is a big support to me. Like, I have a lot of support that they know I'm a good mom and I haven't always had a drug problem in my life.
Now, I know that your mother, she's still suffering from cancer, correct?
Yes, sir.
She did get a visit with the children in this case, correct?
Yes, she did.
And that was when?
That was,
Approximately.
I think back in November-ish or sometime. I can't quite remember. It was a while back.
And you keep in touch with your mom, right?
Yes.
Would she like to have more visits?
Yes, she would. My mom is not doing very well right now, actually. My mom is taking a turn, so.
I was going to ask, has anybody approached your mom for continuing this grandparent-children bond with the kids in this case? Any workers from DHHS?
Absolutely not.
Are there people in your life that you don't have in your life now that you did before that were negative influences?
What do you mean as far as like other bad people that were negative?
exactly.
No, I don't. I cut all them out of my life. I don't need them.
That's what I'm asking. Are those individuals out?
Yeah, I don't even have anything to do with Caleb. No offense to Caleb, but I don't even speak to him.
So are you asking the court today not to terminate your parental rights?
Absolutely. I'm asking them to give me another chance and let me prove that I am a good mom.
Are you asking to begin therapeutic supervised visitation with these kids? Is
Yes, ASAP as soon as possible.
there anything that I've missed that you?
I would like my other kids to be able to have visitations with my kids too and regain that bond.
And what about your mother?
My mother, absolutely, because that means the world to me because I don't know how much time my mom's got left.
Would you like to be able to attend remotely at least any doctor's appointments?
Yeah, I would like to know what's going on with them. My youngest was born premature. Like she had, she's had heart surgery when she was a baby. Like I'd like to know, like she had eye problems ever since she was born. There's just things I would like to know, like
So you're talking
vessel
real.
in the back of her eye, did it heal up normal like it should have? Because when she was born, there's just things like that.
So you're talking real time, not just once 90 days court report. You're asking for real time updates. Is that what I'm hearing?
Absolutely.
Okay. Anything else that I missed?
I don't think so.
Thank you. Other attorneys may have questions for you.
Ms. Thomas?
I have no questions, Your Honor.
Mr. Brooks?
No, Your Honor, I don't.
Ms. Heiss?
No questions, thank you.
Thank you for your testimony.
I do have a follow-up, Your Honor. Has anybody drug tested you since we were in court here last time?
Yeah, I drug test weekly. I just drug tested yesterday.
Okay, have you had any positive test results for anything?
No, just for the marijuana and the Suboxone. It's been consistent the whole time.
Okay, and you're not on the painkiller medication anymore?
No, I was on that for when I hurt my thumb, and honestly, I went to the ER that night. My work took me to the emergency room. They gave me a Percocet, and then after they gave me the Percocet, they said, you're on Vivitrol? And I was like, I looked at him, are you kidding me? I could have just literally went to withdrawal. But they gave me 2 pills that night to take home. I didn't even take them. They gave me a script of 12 Norcos, and that lasted me like a week. And then when I went to drug test the first time after I got the script, I wanted to prove it was out of my system, but they refused to drug test me over there because they didn't have anybody. So I let Ms. Deal know that like this is a problem. They're not drug testing me, yada yada yada. She, that way she was aware. And then after that, I was drug tested, and it's been normal.
When you're prescribed oxycodone, did you tell them that you are an addict and let them know that?
It's in my files. I'm an addict.
Yeah. Did you let them know that?
Yeah, absolutely.
Okay. Marijuana, I know there's an issue made last time, you just brought that up. You had indicated a desire that you did not wish to use it anymore, and you're still testing positive. Tell us about your relationship with marijuana.
I desire to quit, but no, have I quit yet? No, I've cut back, but it is like a goal of mine. But I mean, like, I'm not perfect. Rome wasn't built in a day, one step at a time,
Now, if you are able to have visits with your children, would you be high under marijuana?
No.
You're able to.
If I was to get visits with my children and they told me I had to stop smoking weed to get my visits, I would stop smoking weed. That's how important my kids are to me.
Okay. Nothing further.
Thank you for your testimony. You return your seat. Any other witnesses today?
No, thank you.
Any problems? Ms. Heiss?
I have no witnesses, thank you.
Okay. Closings.
Thank you, Judge. I made a significant closing, I think back in November or December regarding this case. I just reviewed the file, and this court changed the permanency goal to adoption November 29th of 2022. This original petition for termination was filed after the next review hearing, which was held on 2/16/23, in which the permanency goal remained adoption. The department filed in March, amended in April, and we are still lingering with this termination petition. Can definitely give credit to Ms. Patterson for the progress and success that she's made, but wholly missing from her testimony is what these children have endured too. And I believe I said this in my closing argument before, one of the things that has stood out in the testimony that she provided before was alluding to the fact that what she did to her kids was nothing compared to having a broken bone or bones in foster care with a relative. These children, she mentioned today, the youngest particularly had some significant health concerns at birth. And these little ones have been waiting for permanency for a significant amount of time, over 2 years. There's a commensurate responsibility of the parents to comply with and benefit from their case service plan, as it is on the caseworkers to make those referrals. Reasonable efforts. This court has found that reasonable efforts have been made by the department and the agency for the entirety of this case. When there was question about it, we provided the case context to show that there continued to be reasonable efforts despite some issues with the previous caseworker. And I guess all of that to say that the focus isn't on the caseworkers. The caseworkers, the attorneys, the court, we didn't birth or create these children. We didn't create them in a manner that caused them to come into care. We are attempting to support this family to be reunified for 2 years now. Because there wasn't sufficient progress a year ago, we did have to file this termination petition. Those reasonable efforts then had to switch to adoption, which have been made by the caseworker. The agency has continued to follow the court's orders. We've had hearings. Mr. McFarland's fully capable. If there were issues regarding parenting time, He could have easily motioned to have parenting time re-explored, and he didn't. I don't know if that's Ms. Patterson not communicating with him or him not doing that. But the agency continued to come to court, continued to make reports, and this court found that time was still inappropriate for the parents. The court still found that adoption would be the primary goal for these children. The court still found reasonable efforts were being made for reunification. And here we are. At this point, we are asking the court to grant the relief requested in our petition for termination. And if not, then we would like clear guidance on how to move forward with this court's wishes. I believe that the case service plan would need to be revamped. There would need to be a lot of reintroductory periods. But I'm just asking the court to really consider how long this case has been pending, how long it took to make any progress, the permanency needs of these children, and really their best interest, which I know Ms. Heiss really made a good argument on at the last hearing. Thank you.
Mr. Brooks.
The goals and purposes of this court in this type of case are probably more difficult than any other courtroom in this building. And that is to protect children and guide parents into making very fundamental changes in their life. Probably, if the truth be known, changes that have been ingrained in them since they were raised as children. It ain't easy to do. I've, over time, heard a lot of people get up on that stand and others and make all the excuses in the world why it's not their fault. It's all the court's fault. Mostly, you can't say it's the DHHS's fault. And never dawns on them that it's their own damn fault. I didn't hear that today. I heard the motivations of a woman who I think must be a self-starter. It's where we want people to be. We may not have wanted it to take 2 years, but in this case, it appears that it has happened. And I'd ask the court to take that into consideration. I believe every word she said. And I think she has made a genuine turnaround in her life. It took too long. She probably wouldn't argue with me about that. But it got done, and that's a hard thing to accomplish. I am opposed to terminating this woman's parental rights.
Thank you. Mr. McFarland?
Your Honor, this is kind of like a case where somebody's on death row and it keeps being suspended and suspended. And every time my client comes here, there's the anticipation that the kids are going to be returned, and they haven't been. And despite all that, she continues to make forward progress. We have Peggy Moeller, who indicates that nobody's contradicted that any professional, that my client does not need to attend the NA meetings, that therapy that she's getting right now is more intensive by a licensed therapist. She's following all recommendations. She just appears to be constrained, and she's self-motivated. I think the court sees the self-motivation here. Taking a look at my notes, this case, more or less, most of the proofs wrapped up last November 2023. Here we are. Actually, it may have been before that. It's been some time that has been a much longer time than my client's not had any type of visits with these children. Despite that, she continues to progress. She has money saved up, substantial money. I don't think we should falter for not having a place of her own for the children right now, because we don't know whether she's going to get the children back. But she is looking actively right now for a place on her own. Despite that, for her and her children, she has transportation, she has insurance, she has a driver's license, she has stable employment, she has the insurance that will be available for these children there. These kids have not had visits with their other siblings since a long time. I can't see how that promotes a bond, Your Honor. I think we're destroying that bond, and the bond existed. We've heard my client testify about that before, that a bond existed between these kids, between these children. Grandmothers only had one visit, and that's not continued. Every time that I come back here, we have a court hearing, I have, yes, indeed, Ms. Thomas asked this court for my client to have parenting time. This has been a continued request every single time I'm here, is that despite there not being a court decision, that I've asked for parenting time for my client. So we have been diligent in asking for that. My client has visits with other minor children. There's been no investigation, no report, no alleged negligence or abuse for these other children. It kind of gives us a demonstration of how she would be if she were to have these children back. The court did suspend her parenting time when she did relapse, which was May of 23, Your Honor. She's had a substantial term of sobriety, and I don't see that reversing right now. She has support set up that she didn't have before. What has she learned? She's taking accountability. She has taken accountability in other hearings after we began this trial, Your Honor. I think at this point in time, and I know when we were in court last time, the court indicated it wasn't ready to give a decision. That was just about a week ago on this. We are asking that my client have parenting time. The agency, throughout all this period, has never planned on what happens if my client gets better, what happens if this court does not terminate my parents' rights, my client's rights, the parental rights. For the representative for the agency say there'd have to be a new case service plan drawn up. There's been no pre-planning for that. Their goal, I understand that, but their goal and their purpose is to terminate my client's parental rights. I realize that they want stability, they want finality. I realize what we've already argued regarding the best interest factors here. But these best interest factors should shift as my client progresses, Your Honor. And we would like the court to acknowledge that by allowing her to have parenting time, for there to be a family team meeting to discuss, in the event that her parental rights are terminated, what that would look like going forward, Your Honor. I can't think of another case that's dragged on this long, and I realize there's been some problems with some evidentiary issues here, but the bottom line is what suspended my client's parental parenting time, those issues don't exist. Knows how to address stressors in her life. She knows the degree of independence she didn't have before, and the court can clearly see in everybody else that her attitude towards life, or to the court, to the attorneys and everybody else, that she is indeed a different, sober, loving, caring parent. And she also appreciates what the foster parents have done. That they've gone through, and we acknowledge the same stress that she's gone through, not knowing what's going to happen there. And we'll end with that, Your Honor.
Ms. Heiss.
Thank you, Your Honor. In the case service plan, it's the mother's duty to contact the agency monthly. This child, the youngest one, we know was born premature, and the umbilical cord showed when she was born in November of 21, a methamphetamine, amphetamine, oxymorphone, Norco, oxycodone. Today, mom took no accountability for that. We're still talking about her eye issues and that she was born premature. No comment about the reason that she is, each year she's the same age as her sister for most of the year, but it's only because one was born so early. So I didn't hear accountability. I heard that mother is taking Norco again recently for her thumb injury. I think mom concedes the lateness of any change that she may have made. She hasn't been involved in over a year, about a year in these children's lives. She continues to tell us that she's involved with the same guy that in the petition was a problem. And we haven't seen any growth. We continue to see the letter from the McCullough Vargas person who, again, has not seen her evaluation, is relying on self-report, has not partnered with the team to address the things that are lacking. Notably missing is her peer recovery coach that we had heard from at one point. I would ask you to consider that this mother's continuing to use THC. It's not the same as having carrots and cucumbers. It's not, she's promoting it as a healthy part of her coping strategy. However, it is a mood altering drug, and it can be used as a crutch. It was her goal to get rid of that. And she's telling us again today, if it matters, she's willing to stop doing that, using that. The goal of adoption has been long-term and long-standing in this case. I would ask you to consider that we have not seen a significant change that would help this reduce the risk to these at least the one medically fragile child. They have started to meet their developmental milestones. We talked through the best interest of the child factor with these regarding these children. I would ask you to consider that all of the factors point to the fact that they need permanence. They need to continue the bond that they have created with this placement. They had several placements, at least one other placement that was continued the trauma to them. The little one has had increased medical needs. So I'd ask you to consider that the children are well bonded where they are, that the statutory basis, 182 days have passed since the case service plan has been in place. That has been matched repeatedly. We've had so many adjournments in this case, and I would ask you to consider that mother has the wherewithal, at least financially, to provide somewhat for these children, and yet has not. I would ask you to consider at this point that terminating the parental rights is in the children's best interest. Thank you.
Thank you. Well, the court finds that all interested parties were given notice for purposes of today's hearing on the termination request, as well as permanency planning and review hearing. I want to note when I reviewed the file that there was an order that simply adjourned one of our hearings that was supposed to take place in August of 2023. In my review of that, the termination trial piece had been adjourned, but we had actually had a review. It was omitted from file. So I have issued an amended order that simply adjourns the termination trial itself from August 29th to October 10th, 2023, and issued an order that comports with the record that was made on that date that indicates that a review was held and that the permanency planning goal remained adoption. In light of that, I think is the reason why Ms. Thomas filed her request to continue into November to make sure that we had those pieces of information that had been entered in the August hearing, which included, of course, a court report as well as some Native American heritage research documents. So the record is certainly complete at this point. It's a continuing record. It's been open since the removal of the children on December 13th, 2021, which is actually exactly 26 months to the day today, or almost 21, or almost exactly 26 months. A few more days, less than a week. That's a long time for these children to be out of care. When I make the findings for a review hearing, some of them are similar in nature as the ones that I make on a request for termination of parental rights. First of all, whether or not there's been reasonable efforts towards the goal in this case, which was adoption. I certainly do find that those goals or those efforts have been made. I missed deal in the last report period that was detailed in her testimony that we had last time, as well as received by way of court report. Ms. Heiss is in satisfaction of her obligations as guardian ad litem in both contexts, frankly. I have to look at during a review period, any review period, and similarly in when I look at the statute that's requested for purposes of termination of parental rights as to whether or not there's a significant risk of harm associated with returning the children to the care of the parent. Of course, the standard is a bit different. We need clear and convincing evidence along with an additional analysis for purposes of termination. But for purposes of the review, I would find that there is a significant risk of harm associated with returning these children to either parent. Of course, certainly Mr. Caleb Anderson remains incarcerated. I will remain incarcerated until at least the end of the summer, and that is as early as possible parole or release date. He is engaged, it would appear, in some educational services, but we've been unable to really determine what progress he's made in order to see whether or not there's any benefit from those services. We take additional time after that. But certainly today, we would not be able to return the children to Mr. Anderson, which would require a significant amount of time if the court were to continue review hearings as it relates to his rights. goal of adoption would certainly remain appropriate for the children, considering the length of time that the children have been separated from both parents, frankly. As it relates to Ms. Sarah Patterson's progress in the last report period, she has undertaken some efforts on her own, which is great to hear about. I agree with Ms. Heiss that there's continuing concern about use of THC as well as Suboxone and the use of some of those narcotics, although it's certainly understandable in the normal context when you're looking at an injury, when you have the red flags that we have in this case about how severely substances have affected this person in the past. Frankly, I'm surprised that the prescription came out and that she was unwilling or unable to confront her own history on that point and perhaps be forthcoming with the doctor about what a risk that particular prescription posed to her. And I'll review that more thoroughly in the context of the request for termination. But that's a very dangerous decision to make, especially when, as Ms. Heiss noted, we have not heard from a peer recovery coach in a significant period of time. And second, that in reviewing the information from McCullough Vargas, I too have reservations on its authenticity in the sense that it is all self-report, and frankly, it does seem to contradict some of the information the court received in the last review period. Today's letter does reflect a stopping using drugs in May of 2023, whereas the letter at the last report indicated the sobriety date of January of 2023. Which is clearly something that Ms. Patterson had to have reported to her service providers, especially in light of the fact that it's changing. Either that or their record keeping is not as good as perhaps one would want when looking at this particular type of issue, or especially in light of returning children to the care of this particular parent with such a litany of risk associated with and around the drug usage. The letter from the last hearing indicated that she had worked on some kind of domestic violence counseling, but there's no mention of that whatsoever in today's letter. Disturbingly, frankly, indicates while this client has tried to follow the suggestions and requirements of the involved agencies, including but not limited to getting on Vivitrol, Suboxone, or other approved and appropriate medically assisted and monitored substances, it appears to be contraindicated when she either does or does not follow or actually even have a therapeutic or medical need to do this. As I understand it, this is the counselor for the mom. So I'm not sure, and as I understand it, the prescribing person of this particular the medication assisted treatment for Ms. Patterson. And so it's very concerning to this court that the letters seem to contradict each other from the last report period to this report period, as well as seem to indicate that contrary to perhaps their own recommendations, they're continuing to see usage of Suboxone for this particular client. That would be, okay, so here it is. So it's a contradiction of what Dr. Batra is reporting. So again, harkening back to Ms. Heiss's observation, we don't have a person who is part of an informed treatment team, if you will. Clearly, there's a doctor that is prescribing continued Suboxone and medicated assisted treatment. These are not just recommendations. These are things that were done through an analysis of the needs of this mother, and those needs were very thoroughly documented. The use of substances for a very significant period of time really destroyed Ms. Patterson's life, frankly, and the lives of her children, causing their removal and her absence from their life for upwards of a year or more at this point, actually. So I cannot find that there's been progress made in the area of domestic violence counseling, for example. There's no indication of that in the past review period, and in the past 2 to 3 report periods, there's been no mention of it whatsoever, except for a single line in our last review hearing, and I don't know what kind of education that was, program it was, or how long it lasted, because again, there was no mention of it in the last report period. Domestic violence is a serious issue. It was an issue that was raised at the initial outset of this case between both parents. Both parents during the course of counseling denied that was an issue, and apparently that continues to be a non-issue as far as Ms. Patterson is concerned, despite the fact that even as recently as the report period before this one, there was continued domestic violence in her home between residents of the home where she continues to reside. And I do understand that she indicated to us that her daughter moved out and she was the person who was involved in that particular domestic violence situation or situations. But we don't have further verification of that at this point. And all I have to go on is Ms. Patterson's reassurance that that person or those people are not living in the home anymore, and we don't have any more police visits to the home as a result of domestic violence. I have to be able to verify that. So not only do I not have verification of domestic violence counseling, I have indications of domestic violence in the home, which is where the children would be proposed to be returned to within the last 6 months. So that's an issue. There's issues documenting the sustained recovery. I don't have drug testing results really from a significant period of time. We have all the way through a lot of no-shows in 2022, 2023, but as far as the last report period goes, we have that from 9/22, 2023, but in September 9/6, 9/14, 9/19, I have no shows. And then there was no drug testing between 9/30, 2022 and 8/29, 2023. So I cannot verify Ms. Patterson's period of sobriety as she asserts it. I would indicate further that her date of sobriety, as she articulates it in May, is certainly helped along by the fact that she was incarcerated until July 19th. So at best, we do have a few months of sobriety, but without verification as it relates to some of the other areas that she was tasked to improve, I could not agree to return these children to the household. I would also note the home where she continues to reside is the stepfather's home. It's Caleb Anderson's stepfather. She herself told us at different review periods and informed caseworkers. I don't know if she told you directly. I don't think you were around at that point, Ms. Deal, but at least one other caseworker, that this was a person who had supplied her with substances in the past, and had she been the victim of verbal abuse at many different review hearings. I heard from both parents that they were looking to relocate out of the home. That has not happened. I cannot. She still continues to appear even up till today and say that she's looking for alternate housing. And of course, if Caleb Anderson is to be released in August 2024, it doesn't appear that there's any other place for him to return to either. So for all those reasons, I cannot find that there's been progress made really by either parent in the last report period that would allow me to return the children to their home. There's certainly a risk of harm associated with returning the children to both parents at this point for all those reasons. As I look at whether or not to issue the order to terminate parental rights, that means I look at the record as a whole. It's a continuing record, especially in light of the request to evaluate the case under MCL 712A.19B3 CI, which is whether the parents were respondents in a proceeding brought under this chapter, 182 or more days have elapsed since the issuance of the initial disposition order, and the court, by clear and convincing evidence, finds that the conditions that led to the adjudication continue to exist, and there's no reasonable likelihood that the conditions will be rectified within a reasonable time considering the children's ages. The evidence that I'm going to analyze also pertains to the other two sections that the court's been asked to analyze, which is G and J. G reflecting the parents, although in the court's discretion financially able to do so, failed to provide proper care or custody for the child, and there's no reasonable expectation that that would happen within a reasonable time considering the child's ages. And whether or not there's a reasonable likelihood based on the conduct or capacity of the respondent parent that children will be harmed if they are returned to the parental home of either parent. So certainly we have clear and convincing evidence under subsection J, simply from the last 6 months. And I've already made the findings that there's a substantial risk of harm associated with returning the children to either parent today. So we have clear and convincing evidence under J, but supported more detailed is the findings that I'm going to make under the previous two provisions. Okay. As it relates to CI, these two parents are parents who were entered into an initial order of disposition. They were respondent parents at the outset of this. The initial disposition was conducted in front of the review, in front of the referee, excuse me, on January 12th, 2022, following a no contest plea entered by father and mother as a result of potential criminal charges associated with the things that were outstanding at the time of that adjudication. So the dispositional hearing targeted areas including housing, employment, domestic violence counseling, parent education around how substances and use of substances and criminality were interfering with parenting, which of course at that time they were interfering even with where our parents were at and able to accomplish in general. Ms. Patterson was in the Hope House in a rehabilitation program and did not appear for that initial disposition. I'm going to take some time at this point and review the record at each review, since I really put a lot of time into that and trying to prepare for issuing a written order, which will probably also follow. On December 14th, 2021, the court took jurisdiction over both parents under MCL 712A.2B1 and 2B2, indicating that the home, by reason of neglect, criminality, drunkenness, or substances in this case, was an unfit place for the minor children to live. Making the findings, the court relied on the no contest plea entered by both parents, who were both concerned about the criminal prosecution for abuse or neglect. Their youngest child, Kylie, was born severely premature at home at 24 weeks and tested positive for methamphetamines, amphetamines, noroxymorphone, oxymorphone, norco-oxycodone, and oxycodone. Caseworker offered the following summary of the issues contained in the petition. Right now, unfortunately, Sarah is incarcerated. Both parents do suffer with substance abuse issues, which we have tried to work on those. However, there has been failure from the parents to follow through on some of those actions, which led to the discussions about court involvement taking place. Additionally, there are concerns of there is domestic violence, both verbal and physical, possibly in the home. There's a lack of income, lack of employment, lack of transportation, lack of communication with any services, including services at the hospital that are currently caring for their daughter. Neither parent requested placement at that hearing or contested the proposed placement with family. Both had outstanding criminal charges. Mr. Anderson in 3 different counts. Again, on January 12th, 2022 was the initial disposition for both parents. Sarah Patterson appeared from the Hope House. Okay, there we go. She appeared from the Hope House group home where she was receiving inpatient substance abuse treatment as part of a sentencing in Lenawee County District Court for a probation violation. So at that point, she was in rehabilitation as a result of a probation requirement, which is arguably not voluntary. She was on probation for fraud, according to the court report. Transitioned from jail to the rehabilitation center in between hearings. Caleb Anderson was unemployed and remained without housing. Both parents were visiting the children in a supervised setting, and both were ordered into the case services plan produced through mediation. April 11th, 2022 was the first regular review hearing for both parents. Neither parent appeared. The court report and other exhibits entered paint a similar picture for each parent, indicating they were likely still engaged in contact and faced the same challenges. Questions on housing and employment went unanswered due to both the missing March meetings with the caseworker. Some information was available as relates to Sarah Patterson's engagement in substance abuse treatment, but Mr. Anderson had not submitted for a substance abuse assessment despite referral in February. This was especially important, given his psychological recommendation indicated he was in need of an inpatient substance abuse treatment program. Neither parent submitted for any drug treats. As for Sarah Patterson, it was reported she successfully completed Hope House and was discharged 1/31/22, only to be discharged from outpatient services due to failure to appear or engage, and she continued to ignore all court-ordered drug testing. She too cooperated with psychological evaluation and was also recommended to participate in a multifaceted substance abuse treatment program, therapy, parent education, domestic violence education, and abuse and neglect education. Both parents attended a parenting education orientation, but were on their way to getting discharged at the time of the review hearing due to missing several sessions. There were many issues with parenting time, mainly around both being significantly late, missing the same sessions, declining electronic communications, father sleeping through one visit, leaving for 2 hours during another visit. Both were on probation. Sarah Patterson was in warrant status for absconding. Caleb Anderson's probation officer shared he had also failed to report in March of 2022, and if he missed his April meeting, a warrant would be issued. And that was in the court. As for the children, both were referred to early on services and qualified. The older child expressed worrisome indications that she was delayed in her gross motor skills due to not crawling. The younger child had been discharged from the hospital finally, March 7th, 2022, with feeding tubes, oxygen, a heart monitor, and the need for physical and occupational therapy. She had improved by the April 4th, 2022 hearing, but still wore a heart monitor at night and attended regular occupational and physical therapy appointments. Aside from the substance abuse and criminality issues, the psychological assessments from both parents truly explored the dynamics in the household, which were characterized by the assessor from the parent reports as toxic. Quote, the toxicity of their relationship can be evidenced by verbal and physical fights, end quote. Interestingly, the parents appeared together for Mr. Anderson's assessment on March 21st, 2022. The main issue facing Mr. Anderson was the need for clinical residential treatment for his substance use, but the evaluation also marked, quote, clinically, his results indicated a history of considerable acting out behavior, reflecting marked dysfunction. Specifically, he endorsed items reflecting a serious antisocial behavior and involvement with the criminal justice system. Mr. Anderson likely acts out when bored, end quote. These patterns divert his attention, quote, from his child-rearing responsibilities and his energy is drained, end quote. Sarah Patterson's psychiatric evaluation, conducted the same day, contains comments that indicate she remained unwilling to acknowledge the issues that brought her children into care, despite her no contest plea. Deputy Ames, would you mind grabbing the water? I have a few more pages.
I will, Your Honor.
This is a section from the psychological analysis. Thank you. When asked to give her account of the situation which led to her daughters being placed in foster care, Ms. Patterson found, quote, because I had the younger child at home and she was premature. We both tested positive for amphetamines. CPS lied a lot about what happened. Me and Caleb both got incarcerated and I went to rehab from December 15th until January 1st at the Hope House. The CPS report has a lot of lies and false information in it. End quote. This is consistent with Dr. Rickman's observations that she, quote, attempted to paint herself in a very positive light by denying several minor faults and shortcomings that most people acknowledge, end quote. Other tests he administered, thank you so much, were inconclusive due to this presentation. Primarily, we recommended treatment for substance abuse, psychotherapy, parent training with a component which addresses how a history of substance abuse and relationship problems contribute to parenting difficulties. However, it does not reflect whether or not the parents made progress, but the proofs relate some partial progress was made based on the above findings. On June 13th, 2022 was the second regular review for both parents. Both parents appeared from different jails. Outside of jail, both parents were living with Caleb Anderson's stepfather in a home unsuitable for visitation or child occupation due to the condition of the home. Caleb Anderson was on probation in Jackson and Hillsdale County and had an open warrant in Lenawee County for driving while license suspended and a weapons offense, according to the court report. He reported seeking screening for substance abuse treatment with CMH and qualifying for an inpatient residential program still, but had neither entered one nor participated in outpatient services, nor submitted for drug screens. Sarah Patterson did not appear for her initial appointment and was discharged from her outpatient services following Hope House completion 1/31/22. The parents were living, planning, and participating in visitation and supportive services together until Sarah Patterson was arrested in the days ahead of this review here. They were regularly, significantly late to visits and unprepared, according to supportive visitation reports. For these reasons, the order notes neither made progress during that report period. September 8th, 2022 was the third regular review. Neither employment nor housing arrangements changed during this review period for either parent, with the exception of 3 weeks spent in Lenawee County Jail for Caleb Anderson, and the fact that Sarah Patterson appeared for this hearing from Lenawee County Jail. Caleb Anderson still had pending criminal matters in Jackson, Lenawee, Hillsdale, and now also Monroe County. Sarah Patterson did complete her supportive visitation program. Caleb Anderson did not complete the program due to his incarceration and did not respond to a re-referral. In the area of substance abuse treatment, Caleb Anderson went to an inpatient facility, but was discharged after making verbal threats to staff. The facility notes his level of need still remains inpatient at the time of his departure. Sarah Patterson told the worker about several programs she had enrolled in, but the facilities either denied this or informed her there was no release on file to verify them. Neither drug tested at all during that report period. As for individual counseling and mental health treatment, Mr. Anderson wasn't attending and informed the worker he did not need counseling for domestic violence at all. Sarah Patterson simply ignored this requirement on her case services plan. Caleb Anderson, accepting during incarceration, attended parenting time without issue. Sarah Patterson's visitation was restricted to DHHS supervision due to a physical fight during a visit at the caretaker's home and had a major issue at the first DHHS visit. She missed other visits and was subsequently required to confirm ahead of time in order to even exercise parenting time due to her inconsistency. For these reasons, the order notes neither parent made progress. On November 29th, 2022 was the fourth regular review for both parents in the first pregnancy planning hearing. Sarah Patterson did not appear. Caleb Anderson appeared from Lenawee County Jail, where he'd been since October 3rd, 2022. Neither had established housing, employment, transportation, or engaged in counseling or substance abuse treatment. Sarah Patterson was missing so many visits that the court reduced her visitation to once weekly with the requirement to appear an hour in advance to allow her to visit. Both were so disconnected from the children that the Department of Health and Human Services, the agency, and replacement had to be officially recognized with the authority to consent for physical, medical, and mental health needs of the children. For these reasons, the order notes neither parent made progress and the goal was changed to adoption. On February 14th, 2023 was the fifth regular review, second permanency planning hearing conducted in front of the referee. Sarah Patterson did not appear. Caleb Anderson remained incarcerated, and the agency faithfully supplied him updates and parenting education materials. He was not engaged in any other services. He reported to the worker he had pled to a new domestic violence charge and would be incarcerated for at least another 2 months in Monterey County Jail. Sarah Patterson had only attended one visitation and had a warrant out for her arrest for violation of probation. Truly, neither parent made progress in this report period, and the order notes neither made progress. The permanency planning goal remained adoption. At this point, there is, as referenced by all of our attorneys today, a few interruptions in the reviews, which ended up causing some confusion and delays. March 20th, 2023, the department filed a supplemental petition requesting termination of parental rights of Caleb Anderson and Sarah Patterson. Caleb Anderson was served in Hillsdale County Jail on March 28th, 2023. Sarah Patterson was served in the jail on March 28th, same day. In April, they filed an amended petition for termination, again against both parents. On April 25th, 2023, the review/permanency planning hearing was adjourned due to the surprise assertion by Sarah Patterson that Caleb Anderson is not the father of the younger child, as well as the need to consolidate the review with the termination trial. Trial on the termination petition is consolidated with the next scheduled review and was set for May 15th, 2023. May 15th was the sixth regular review and the third permanency planning hearing, and the start of the termination trial. The termination trial was adjourned after the attorneys reported new information regarding possible Native American heritage. However, the review and permanency planning hearing were conducted. Caleb Anderson appeared from Hillsdale County Jail, awaiting a 5/22/23 sentencing for a felony breaking and entering. The agency continued to update Caleb Anderson with reports, documents, pictures, and monitor his access to services during incarceration. Sarah Patterson appeared from Monterey County Jail, where she was lodged on March 9th, 2023, following the only parenting time she exercised during this review period for 45 days on a violation of probation. She tested positive for meth, marijuana, and morphine on May 1st, 2023, just days before she was arrested again on May 8th, 2023. Again, truly neither parent made progress in this report period, and the order notes neither made progress. Permanency planning goal remained adoption. Parenting time for both parents was suspended pending resolution of the termination petition. Case was scheduled to combine the next review and PPH with the hearing on the termination for July 25th, 2023. At this point, there are some further unexpected delays. The hearing scheduled for July 25th, 23 were adjourned to August 1st, 2023 due to the unexpected passing of an immediate family member of one of our attorneys. The August 1st, 2023 hearing was adjourned to the 29th after the discovery that arrangements had not been made for Caleb Anderson to participate in prison. The attorney for Sarah Patterson also requested the adjournment to consolidate the review for both parents. On the 29th of August, 2023, testimony finally began for the seventh regular review and fourth permanency planning hearing. The hearing began without Sarah Patterson and her attorney due to the request to allow time to prepare a release of parental rights. The record reflects review of the issues that brought the children into care as relates to Caleb Anderson, documenting little to no progress on areas identified in the initial petition. Continued incarceration with very little engagement in services or visitation when he was not incarcerated. Areas targeted included treatment for substance abuse, need to establish housing and employment, eradicate criminal behavior and thinking patterns using counseling and parenting education. In the time Caleb Anderson had outside of incarceration, the only complaints he had was submitting for a psychological evaluation, the results of which he disregarded. He did attend visits, however, was regularly unprepared and late. And he did have some limited participation in a supportive visitation program. Little or no progress occurred in every other area of his case, compounded, of course, by his incarceration. In fact, Caleb Anderson appeared from prison confirming that his earliest possible release date was August of 2024. In compliance with the incarcerated parent protocol, the foster care caseworker was aware of the services at the prison, knew he was on a wait list for them. She maintained contact with him frequently enough to know that he had transferred from jail to a holding center, then to the prison where he had appeared for a hearing. Sarah Patterson changed her mind. She decided to proceed with the termination trial instead of releasing her parental rights. So the review also encompassed testimony and information regarding her progress, which was very limited. She had been incarcerated from March 9th until July 19th, with only the 2-week break in May. As of August 29th, 2023, she was no longer incarcerated, but did not have appropriate housing, verified employment, or any evidence that she had engaged in parent education, mental health, or substance abuse treatment. Sarah Patterson testified she was taking Suboxone, doing substance abuse treatment, counseling, therapy, and NA classes online. However, she had not provided any of this information to the worker, and upon cross-examination, she admitted the prescription for Suboxone had been just issued the day before the hearing, and she was not actively involved in any meetings. Her employment was 2 weeks old, and she was residing in the housing previously deemed inappropriate, still with Caleb Anderson's stepfather. And she continued to insist CPS had falsified allegations in the initial petition, and that she didn't need any treatment other than for substance abuse. Despite the domestic violence charges that arose out of the relationship between her and Caleb Anderson that had been pending at the initial disposition, and of course her no contest plea admitting the issue. She grudgingly admitted she had missed visits when she was not incarcerated, but then blamed her family members for the suspension of her visitation rather than acknowledging her lack of progress on the case services plan that triggered the petition. Unfortunately, there was not enough time on August 29th, 2023 to allow for the full testimony from both parents on the termination petition. So with the consent of counsel, the court concluded a review and trial on the termination petition was adjourned to October 10th, 2023. There's a question as to case context. The court ordered the production of the foster care caseworker social work context logs for review at the next hearing. Then a court docket conflict forced the adjournment from October 10th to November 3rd, 2023. On November 3rd, 2023 was the 7th regular review and 4th permanency planning hearing. This hearing also continued the trial on the termination petition, consolidated with the long overdue review and permanency planning hearing, as is typical practice with the court. The order notes partial progress by Sarah Patterson, no progress from Caleb Anderson. He appeared from Newberry Correctional Facility at that time. He had been updated with a letter and his children, a picture, and a request to update the caseworker and services. He was engaged in an advanced substance abuse program, employment readiness, batter intervention program, and an academic program, all required for parole. Appears to be incarcerated for the Hillsdale criminal case with an earliest release date of August 26, 2024, and a maximum release date of September 26, 2027. The amount of progress Sarah Patterson made was difficult to ascertain. She appears to be in recovery, testing for medication-assisted treatment and reporting for psychiatric medication evaluations monthly, and her drug test count coming back from THC and BUP, but she seems to only test when she wishes to, and continues to try to blame the Illinois Department, Center, doctor's appointments, or her employment for the gaps in testing. She had corrected some issues with her housing, but that housing continued to be with Caleb Anderson's stepfather, which has never been appropriate housing simply because of the physical dangers presented in the home, but by her own reports of substance abuse, supplying of substances, and verbal abuse in the home. So this is the report period that I just went over also in my findings for today's review period. I would note that there appear to be conflicting reports during that time frame, since her daughter moved into the home with her boyfriend and the police had been to the house numerous times during that report period for domestic violence. Around the issue, she's still not engaged in individual counseling or domestic violence counseling or education. There's a letter in strong support of her progress at Nicola Vargas from October 31st, 2023. Again, however, it reflects a sobriety time frame extending from January of 2023, which directly contradicts the evidence of use in March and May of 2023, which sent her back to jail until July 19th, 2023. The court indicated it would take the matter of termination under advisement, allowing for written closings, but also set a future review for January 26, 2024. Then there was the request that I've already talked about to make sure that the record was complete with the August report, and those Documents were readmitted on November 17th, 2023. Part of the delay after that point in issuing the opinion of the court was to allow one very dedicated court reporter to supplement the file with transcripts. Several of the hearings were held by the referees, 2 different referees over the period of time that this case was open. And given the gap in time and the potential progress made by Sarah Patterson in the meantime, there was another review, PPH, and extension of termination of proofs was equitable at the time based on her statements. Fast forward to today, the only additional information we have for purposes of verification of her engagement in substance abuse treatment is, of course, the McCullough-Varga letter, which the court has already analyzed at length, and as has Ms. Heiss, and found to be lacking. We still have the gap in parent education, domestic violence counseling, and how those domestic violence issues and substances impact parenting. We have her residing with the stepfather, and with no indication that any of the self-reported issues that she raised over the period of time in different court hearings have been remedied. And again, presentation of herself in a very favorable light, which is continues to be consistent with the psychological evaluation remarks, without verification of success in many ways that I've already articulated as part of the findings for the review here today. So for those reasons, I do find that there is clear and convincing evidence that neither of these parents has made substantial progress on the barriers that were addressed. It's certainly been more than 182 days. Again, we're at 26 months and less than 7 days. Mr. Caleb Anderson never remedied his criminality and for much of the case was unavailable to services and visitation during that time. During the time he was out, failed to take advantage of those. So I cannot find in either case that there's any reasonable time frame allowable to allow these issues to be remedied. For example, around the issue of domestic violence, she's never truly taken any responsibility for it. And again, we've had some indications that it continues to be in her household in the last 6 months. So that's a significant risk in and of itself to these children, let alone the lack of verification around true substance abuse recovery for a significant period of time. So I do see that there's some progress in some areas, and I want to congratulate Ms. Patterson on that. But I cannot, in good faith, allow the return of these children. And I do find that there is very convincing evidence under all 3 statutes that I was requested to analyze to terminate the parental rights of both of these parents. Mr. Caleb Anderson, just as a side note, earliest release date is August, had a lot of time to try to engage in services before that point, didn't do it. If he was released, it would be months and months of him to demonstrate housing, transportation, engaged in parental education in all of the areas that he hasn't engaged in, demonstrate sobriety for a significant period of time, demonstrate, abstinence from criminality. It's not reasonable to ask these children that have already been in care for a period of 26 months or more and are well bonded to their placement to wait any longer for stability and permanency. These children remain young. They had significant issues. The younger one, both, as Ms. Heiss indicated now, are beginning to finally meet their developmental milestones. And although my analysis didn't go into very much of the developments for both of them across the period of time the case was open, they have made some progress in some of the immediate developmental milestones. Ms. Patterson, would you like to step into the hallway? I would indicate that it did come to the court's attention at one point that there was a risk of harm associated with one of the placements for these children. And unfortunately, because of the lack of progress at that point, parents were not an available alternative placement in another significant time of need. Anyway, the best interest factors require a finding by preponderance of the evidence. It is the only time that the court compares the households offered to the children. Of course, and analyzes the bond. There was a relative placement that the children had to be removed from, so that does not apply in this case. But the parent-child bond in this case between both of these children and both parents was eroded long before the suspension of parental rights occurred in May of 2023. I reviewed that very specifically to look at that issue in light of Mr. McFarland's remarks. The suspension of parental rights has been in place for a significant period of time. So I did look to see whether or not that had affected the ability of the parents to form a bond with the children, to find things like Ms. Patterson had been so disconnected with parenting time and the children that I had to give the department the discretion to consent for physical, medical, mental health needs. That her parenting time was significantly reduced more than once for her failure to appear. Her unreliability, I had to require at one point that she appear an hour ahead of parenting time just to make sure that we didn't ask these children to move to a visitation that the parent would not be there for. So, and then of course you have Mr. Anderson's continued and regular incarceration, removing him from the ability to maintain his child-parent bond. The responsibility for that lies only at his feet. So the parent-child bond is very much eroded, but was very weak to begin with. This court finds based on the evidence that I have in front of me over the course of the past 26 months, which is really a very significant period of time for both of these children, nearly their entire lives, frankly. They both need stability and permanency. They are finally beginning to reach those developmental milestones, but both had early on assessments and services and were able to overcome many of those challenges. But they need to be able to maintain that stability and permanency in order to move forward on that. And the termination of parental rights is a necessary piece of that to allow them to remain in the home where they are having their needs met, where there is no risk of domestic violence by the adults in that home. We have, of course, the support of our caseworker, our lawyer guardian ad litem, and arguably the risk of harm. The children are really too young to express any kind of preference, but they are also placed together, which is a resiliency factor that they will continue to enjoy. They're bonded to that placement. There's a high likelihood that they would be adopted, and that is well on its way. Ms. Deal has been working on that, and before that, the other caseworkers have been working on the goal of adoption for a very significant period of time in this case. So for all those reasons, I find that it's in the best interest of both of these children independently that the court terminate the rights of Caleb Anderson and Sarah Patterson, and I will enter an order to that effect today, attaching the documentation I reviewed on the record today as well to that. They will, of course, have the right to appeal that within 21 days, and the order will be provided to them with the opportunity to request court-appointed legal counsel if they cannot afford the same. They will also be provided with information to keep their information up to date through the Department of Health and Human Services for purposes of releasing any identifying information if he or she so chooses to do that, or to deny that release, or to revoke that as they may feel or find appropriate. We'll have a review hearing issued from today's hearing, and then set. Children will be committed to the Michigan Children's Institute or the Department of Health and Human Services for purposes of adoption or some placement. There will be no more efforts towards the goal of reunification or to prevent removal, and the court will monitor the case to see it through to the finalization of adoption, which continues to be the appropriate goal in this case. Their first post-termination review May 8th at 10 o'clock. Unless you have any questions, that's all for today. I will not have the order ready for you. We'll get it out to you in the mail and get it over to you as well. Of course, Mr. Anderson, if you choose to exercise your authority. Any questions?